Thank you.
Okay, thank you. Thank you all. Good afternoon. I'm Mark Ells, Town Manager, and this is the public hearing on proposed amendments to the Town Manager's Regulation, Part 4 of the Code of the Town of Barnstable to adopt grant of location regulations. These regulations provide application procedures and standards for the construction of wireless communication facilities located in the public right-of-way. It's Thursday, March 23rd, at 2 o'clock, and we're conducting this hearing via Zoom. I will, well, first of all, the full text for this proposal, these proposed regulations, are available on the town website. They're under the town manager's department, and it's referenced as proposed grant of location regulations. You can also get a copy from my office if you're unable to access our website and would like a copy. You can call in and we will get you that information. I'll just outline for a moment how the hearing will proceed, and then I'll turn it over to my staff to begin the first part of describing the proposed regulations and the justification. So this is a town manager regulation and a town manager hearing, and the hopeful outcome of this process will be to adopt a regulation that falls under the town manager. I state that numerous times because this is not something that goes to town council for approval. We do a public hearing for this, and we've commenced that. The way that I'll do this is initially, as I've just stated, I'm going to turn the meeting over to our town attorney, Karen Nover, and our town attorney and supportive staff and consultant will review the proposed regulations. Once they've concluded their portion, I will open it up to public comment, and Lynn Poyant, as she has introduced already, will ask you to unmute and provide comment. Once we've received all public comment on this, we will take this under advisement. And we've already received some written information. We encourage everyone who, certainly everybody who has submitted this, their written submittals will be taken as part of that advisement and considered in moving forward with adoption of these regulations. We also encourage all of those who are not participating at this time or aren't viewing this right now to take the time to view it and then to submit. I will keep this process of review going for 30 days so we can receive everybody's comment. We encourage it to be in writing, and all of that will be taken under advisement as we proceed with either adopting the regulations as proposed, modifying the regulation to include those proposed changes, or actually taking it back under because of significant changes and holding additional public hearings. I will let the town attorney share with you how we will share a draft modified version of incorporating these modifications and the process concurrent and subsequent to that, so that everybody can see that we've done it and then adopt the regulation. And so at a minimum, it'll be 30 days under advisement, and then either adoption, modification and adoption, or additional public hearings, depending on the types of comments we receive. At this time, I will stop the introduction, and I will ask our town attorney, Karen Nober, to take over the first portion of the hearing.
Thank you, Manager Ells.
I would like to just take a moment to introduce Attorney Alan Mandel, who is with the law firm of Ferreira Scabo, who has been serving as outside counsel to the town in the development of these regulations. Attorney Mandel has substantial expertise and experience in telecommunications law, and he has worked very closely with the town's legal department and the town's planning department in developing these regulations. And I'm going to turn this over to Attorney Mandel now so that he can give an overview of the regulations.
Okay, thank you, Karen. As Karen mentioned, I have been a legal advisor on wireless issues to the town. And I'm going to provide a general overview of the proposed grant of location regulations. First, I'd like to touch on the need for the regulations. Since the passage of the Telecommunications Act of 1996, there have been numerous changes in wireless law, evolutions of technology, and of course, the demand for wireless services has grown substantially. With the changes in technology and law, municipalities are confronted with increased use of the public ways as a place for locating wireless communications facilities. Much of the Telecom Act case law and rules evolved when everyone was talking about cell towers, not attachments to utility poles in the public ways. So confronted with these changes in federal law and the evolution of the industry, what locations it wants to utilize, it was apparent that many towns needed to adopt regulations or bylaws to bring themselves into compliance with a number of federal requirements, some procedural, some substantive, and to better position themselves to manage the use of the right-of-way by the wireless industry. So those two things in mind, the need to comply with federal legal requirements and the need to take specific actions to exercise more control over the use of public ways to the extent permitted by law. The town has chosen to act through town manager regulations, which are authorized, and by virtue of having regulations, we think that the town is in a better position to respond to any further changes that occur. These are new regulations, so the experience developed with them, and the opportunities to refine them, modify them, as experience and law and technology may dictate. So we think that's the right approach. Part of the process here was an extensive review of similar laws adopted in other communities in Massachusetts, outside of Massachusetts, by government bodies. We also reviewed a number of models that have been advanced by the wireless industry, by the National Association of Telecommunications Officers and Advisors, and by groups such as Americans for Responsible Technology, Physicians for Safe Technology, recommendations by the Environmental Health Trust. These all went into the process of coming up with what we felt would be a good set of rules that would bring us into compliance with federal law and adopt standards consistent with state legal authority and the federal limitations on that authority. I think, as Mark mentioned, there's some things that are not covered by these regulations. They don't apply to private property or private ways. They are not zoning regulations. They arise out of a separate statute, Chapter 166 of the Mass General Laws. And the state standards that get translated into a lot of detail in these regulations, again, are under Chapter 166. Section 21 of that statute says that the parties permitted to use the public ways cannot incommode the use of public ways by others. Incommode is a term of art. It's in a statute. At least the courts in Massachusetts have said that it covers more than mere physical inconveniences. It can embrace other things that, in addition to that, it goes beyond dealing with danger to the traveling public. In addition, under Chapter 166, Section 22, the town has a traditional police power authority to regulate the placement, construction, and modification of facilities going into the public ways. Generally, these police powers deal with aesthetic standards, how the facilities fit into the town, the location, height, appearance, impacts on things like tree lines, compliance with various applicable laws that need to be assured. And the regulations try to really stem from those types of requirements, the incommode statute and general police power considerations. Under federal law, these powers are recognized. However, there are some limitations placed on those powers. First, there are some substantive limitations. One example, the town cannot take into account the environmental or health effects of radio frequency emissions to the extent that the wireless facilities are in compliance with the FCC's radio frequency emissions regulations. There are things, geez. Gosh, I just lost the screen.
We can still see you.
Oh, you can?
Yeah.
Okay. Yeah, I must have hit something and lost the screen. Let me see if I can get back in. Thank you. Radio frequency emissions, there are things that the town can do that relate to assuring compliance with the FCC's regulations. Another limitation is that an action might be legitimate under the substantive law of Chapter 166, but if the effect of that action is to prohibit the provision of personal wireless service, the action of the town might be preempted. So that's a consideration to take into account. Also, the town's practices cannot unreasonably discriminate among functionally equivalent services. That's another standard. Also, not directly related, but the FCC essentially eliminated the right to impose moratoria on wireless permitting with a few minor exceptions. So that's the kind of an overview on the substantive side. On the procedural side, there are a number of requirements. State law generally requires public hearings and notice of those hearings, which are incorporated into the regulations. The standards have to be published, made publicly available, both for the public and for wireless applicants, so they know, what it is they have to comply with. The decisions that are reached must be in writing, and the decision taken must be based on a statement of reasons, and the reasons themselves have to be supported by substantial evidence in a hearing record. It sounds simple, but it isn't. There are lots of steps to be taken there. Procedurally, the town also has to act on applications within a reasonable time. That's a statutory standard. The FCC has interpreted that to mean that objective intervals called shot clock intervals are applied to different types of applications to determine the amount of time that's deemed reasonable. In some cases, the shot clocks create a presumption that if you exceed it, you've acted unreasonably, but you have an opportunity to rebut that. And in the event that either parties or both parties want more time, they can enter into tolling agreements to defer the running of the shot clock interval to allow more time to do what they need to do. The decisions come out, they're reviewed, regulations acknowledge rights of appeal from town decisions. Much of this tracks what would be true under state administrative law, but it's kind of combined together with requirements under federal law. And we've tried to cover that in detail in the proposed regulations. So that's a high-level description. And I think one other point to mention, there is an application form that is under development. It will be finalized once these regulations are effective, so that they will match up and be consistent. So that's something that will be forthcoming. Thank you.
Before we go forward, Elizabeth, did you want to just briefly announce who we received written comments from?
Thank you, Attorney Nober. Elizabeth Jenkins, Director of Planning and Development. We received 2 comments in writing. One from Mr. Jeremy Crandall, Assistant Vice President, State Legislative Affairs from a group CTIA, the Wireless Association, dated 3/23/2023. We received another communication from Douglas A. Wood, National Director of Americans for Responsible Technology, along with an attachment dated 3/17/23.
Okay. At this time, that's our staff summary of the proposed regulations. And thank you, Elizabeth, for identifying those 2 written comments submitted to date. But again, certainly we are going to take any public comment now. That'll be the next section we're moving into. And for the next 30 days, certainly written comment. I encourage it to be written. And we'll take all of that under advisement as we move toward approval of these proposed regulations. So at this time, Lynn Poyant, I'll ask you to facilitate the public comment discussion for us. Thank you.
Thank you, Mr. Els. Lynn Poyant, Director of Communications. At this time, I'm going to invite the speakers, you to speak in the order in which you arrived at the meeting. We would ask that you identify yourselves. We know that there are some people that just have a first name or initials or somebody's iPhone. And so we are going to ask you to announce your first and last name prior to giving your testimony. The first person up is Molly. Molly, would you like to have public comment? And if so, you may unmute.
I will unmute to just tell you it's Molly Sproul, but I don't have a comment at this point. Thank you.
Thank you. Our second person is Janet. Janet, would you like to unmute and provide public comment?
Hi, my name is Janet Davis, and I do have a couple of comments I'd like to make. I was very happy when I learned about the strand antennas that could be outside people's homes on their wires that include cable apparatus and the like. And I'm concerned because I don't feel as though, A, they'll understand what it is exactly. They'll just think it's another type of, something that they need for their cable or, whatever is out there right now. But it's just, I don't think that they would be made aware and understand that it's something that's emitting EMF emissions and could be, is a danger to their families. So I'm concerned about that. I'm concerned about the integrity of these, given the fact that we face such severe storms, nor'easters, almost quarterly now. So I don't know how vulnerable they would be to the storms that we get on the Cape. And also, I feel as though that the telecom must prove that there's no other way for them to get this coverage to our homes, that we would have to have it directly outside. So I feel as though in the regulations, there should be proof that there's a need for that and that they've exhausted other options. And also one item that I really would love to see, and I strongly urge the town include in the new regulations, is that property owners within 250 feet of a proposed antenna or any type of cellular apparatus be notified. Had this been done during the application process for the T-Mobile tower at 565 Main Street in Centerville, 19 homeowners would have been notified. That's 19 people who would have had a voice to say, we don't want this on our main street in Centerville near our homes. So I definitely would like to see that included in the new cellular regulations. And lastly, I believe it's extremely important that the updated regulations include language where applicants submit them under the pain of penalty and perjury, so that there's some kind of way where the town can go back and, correct anything that they find that was misleading or just a blatant lie, or I don't want to say lie, but something that needs to be rectified. And Centerville Concerned Citizens do want to thank the town for their hard work on this critical issue. And we're really excited and anxious to see this get completed. And that's my comment. Thank you.
Thank you, Janet. Next up, we have Marissa Jackson from Eversource. Marissa, you may unmute.
Good afternoon. Thank you very much. Marissa Jackson from the Eversource Rights and Permits Department. We have no further comment, but thank you. We're appreciative of, listening in this afternoon.
Thank you. Next, we have Sean Conway. Sean, you may unmute.
Hi, thank you. I'm attending here to listen in today. I'm from Verizon Wireless, and thank you for having me. I have no comments at this time.
Thank you, Mr. Conway. Next, we have Jennifer Lynch. Jennifer, you may unmute.
Thank you. Yes, thank you for the opportunity to speak. My name is Jennifer Lynch. Thank you for the opportunity to comment on the draft regulations today. Thank you to Town Manager Mark Ells, to his legal team, the Planning Director. Thank you also to Nick Atzelis and others for drafting a good set of regulations in the midst of an ever-changing legal and technological landscape, and in the shadow of a juggernaut of an industry that's fighting regulation and pushing a dangerous product on the public. While the regulations are strong, there are still a few important provisions that the Centerville Concerned Citizens would like to see included. Some of these are outlined in a March 17th letter to Mr. Ells from Doug Wood, the Director of Americans for Responsible Technology. Elizabeth mentioned this letter earlier. The letter's available to the public. So I'll mention briefly each item in that letter. As anyone who wants to read it, it's public and available. If anyone would like a copy of that, please let me know also. Public notification, as Janet mentioned just a few minutes ago, high on our list of requests and recommendations for additions to this draft is better public notification. We would like to request that you add into the regulations a requirement that applicants seeking to place antennas on public ways, or really anywhere, notify within 5 days by certified mail property owners within 250 feet of the location, and that a public meeting be held on the application. The public should have a right to know about proposed actions that will affect their well-being, their happiness, safety, quality of life, and property values. This would go beyond the state law requirement that only abutters need to be notified. I feel 250 feet is a short distance, and neighbors within that distance have or should have a right to be notified. Honestly, it should be 500 feet or more, but 250 may more likely survive a challenge. The Centerville Concerned Citizens was created 5 years ago when a cell tower was installed in the South Congregational Church with no notice to most neighbors. It was accidentally discovered at the 11th hour, and a long legal battle followed to stop it, one we eventually lost. The neighbors should have been informed and been given the opportunity to express their concerns and objections. Keeping the public in the dark about actions that have a significant effect on them is incompatible with good government, democracy, and transparency. Not ensuring the public is informed benefits no one except those who don't want the public to know what's going on. This would also allow the public to review applications ahead of time, which is also important. We urge you to have a 250-foot notification requirement and a public meeting requirement stated in the regulations. The town manager now has the option of calling a public meeting, but we don't think that's enough. The public has a right to be heard, and the town has an obligation to listen. Fake screening. I ask that the town include in the regulations a ban on cosmetic screening of antennas that include PFAS chemicals, substances that pollute the environment and damage the health of the public and wildlife. This is becoming a big issue in some locations, particularly in areas with fragile environments like Cape Cod. Damage to humans from PFAS chemicals include cancer, liver disease, thyroid damage, and reproductive damage. Fire and safety. We would like to recommend that specifications for fire and safety be updated to respond to rapidly changing weather conditions due to climate change. These suggested specifications are detailed in an attachment to Mr. Wood's March 17th letter to Mr. Ells. They're technical and probably dry reading for lay people, but nevertheless very important to protect public safety. This attachment is also available to the public. It's titled Municipal Code Recommendations for a Changing Climate. One significant public safety concern, as Janet also mentioned a few minutes ago, is strand-mounted antennas. Among other reasons, because they're vulnerable to collapse or damage during storms and other dramatic weather. They swing on wires, and if the wires come down, so do they, creating a serious hazard. Many cities and towns are increasing insurance requirements of telecoms significantly, such as $5 million per occurrence, to cover liability due to structural damage, fire, flood, wind, or claims resulting from exposure to pollution, including RF radiation. We also recommend the inclusion of language allowing the town to revisit any permit for a wireless antenna in the event that the FDA changes its policy on human exposure to RF radiation, and/or the FCC changes its human exposure guidelines, and/or there is a court decision or change to the Telecommunications Act allowing local governments to consider the potential health effects of exposure to RF radiation in making decisions about antenna placement. I attended a webinar yesterday where several attorneys who regularly draft communications technology regulations for municipalities described in detail the many ways telecoms get creative with the truth and even outright lie when submitting applications for antenna permits. Because of this, many communities have in their regulations language stating that the applicant submits the application under the pain and penalty of perjury, such that the community can revisit the permit, if it's proven that the applicant misrepresented the truth on an application. I think this would be very important to include in our regulations. Applications are technical, and a lot of information in them is indecipherable to the average person, and therefore we rely on experts and professionals to submit accurate information. If they do not, the benefit they got by submitting erroneous information, that is the permit, should be revoked or at the very least put back on the table, and the town should have the right, in writing, to do so, and in fact has a responsibility to do so. This should go without saying. If something is obtained on false pretenses, it should no longer be valid. However, I think it should be said and said in writing in the regulations. The application itself may be the appropriate location for this clause, if you considered including it, which I hope you do. I think this would go a long way toward deterring misrepresentation and protect the public if in fact a permit is issued based on false information. Application. I'd like to request that the application to accompany these regulations be made available for public review prior to approval. Finally, I encourage the town to look into fiber optics for our internet communication infrastructure, as it is a safer, faster, more reliable, more economical communication technology. Thank you.
Thank you, Ms. Lynch. Next up, we have Jeremy Crandall from CTIA. Jeremy, you may unmute.
Yes, can you hear me okay? Great, thank you. Town Manager Els, other town staff, and legal counsel. My name is Jeremy Crandall, Assistant Vice President. I'm here to testify on behalf of CTIA, the Wireless Industry Trade Association, with comments related to the grant of location regulations before you today. Let me begin by saying that CTIA and its members are strongly committed to improving connectivity for residents and businesses in this town and communities across the Cape, as innovations in telehealth and distance learning require reliable mobile connectivity, as emergency response incidents demand consistent mobile access, whether they happen on the beaches in the summer months or in villages throughout the year. Our members are strongly committed to ensuring that this community not be left behind when it comes to accessing wireless services, responding to what is exploding growth that we are seeing in demand at around 30% per year, and we expect that to continue for at least the next decade. Responding to that growth requires policies that ultimately ensure regulatory predictability for our members. And so I want to start with, as it relates to the regulations, that we appreciate very much that the purpose and intent of the regulations recognize the benefits of wireless to this community and the need to be consistent with applicable state and federal requirements, as noted in the regulations. Unfortunately, there are a number of provisions in the regulations that we feel do not ultimately achieve that goal. Much of what I'm about to say, and more is included in the written testimony that Elizabeth mentioned that we submitted. I just am going to touch on a couple here, and then obviously happy to answer questions if that's a part of your dialogue here. But it's important to point out, first and foremost, that Congress, the Federal Communications Commission, the FCC, which is essentially our federal regulator, and the courts have long held that many of the policy decisions that this regulation ultimately impacts are in fact governed by federal law or the FCC has the exclusive authority to regulate. And I want to share a couple examples of this. This starts with the provision that requires third-party and technical review of what are network design decisions. That intrudes on the provider's own determination of how it can achieve reliable service for the community. That directly conflicts with the Federal Communications Act. Or requirements, and I know there's been a lot of dialogue already about it, or requirements related to RF radio frequency emissions, which Congress and the FCC have expressly preempted local governments from regulating. And then there are a number of other provisions that do create unnecessary and excessive hurdles for our members. This includes what are exceedingly short or otherwise unclear timelines for permit approval and project completion, and then also distance limitation and bonding requirements that we feel are extraordinarily excessive and would effectively prohibit deployment of wireless infrastructure. So I'll just close with, again, given the exploding demand that we are seeing from consumers for more wireless services right now, this is precisely the type of challenging regulatory environment that challenges our expansion in investment in infrastructure. And so our members, I know there are several that are on here today. They're eager to continue to work with you, and as are we, on policy approaches that benefit the town's efforts to improve connectivity, protect the role of local government, but ultimately also comply with federal law as well. And so I appreciate your time. I appreciate the opportunity to speak to you all remotely, and I will stop there. Thank you.
Thank you, Mr. Crandall. Next, we have Bruce's iPhone. Bruce, if you'd like to give testimony, could you unmute and please identify yourself?
I'm fine. I don't have any comments to add. Thank you, though, for asking.
Thank you. Next, we have Steve Johnston from Open Cape. Steve, you may unmute.
Thank you. Hi, I'm Steve Johnston. I'm the Chief Executive Officer and Executive Director of Open Cape. Good afternoon, Manager Ells, Ms. Jenkins, rest of the staff. Thank you all for inviting me to participate today. We don't have a huge position currently in the wireless spectrum. Obviously, our bread and butter is fiber connectivity, and we believe that direct fiber access, wireline fiber versus wireless, is probably, in our purposes, the best way forward to make sure that we have reliable, redundant, affordable connectivity for all segments of our population here on the Cape and Islands and southeastern Mass. I'm incredibly interested to listen to this discussion, though, and follow it, because at some point in our evolution, wireless is becoming part of the arrows that we have in our quiver on how to deliver connectivity to folks. And in some cases, building fiber to a location or a neighborhood just doesn't make economic sense. And until that happens, looking at wireless considerations could be something that's on the table. So for us, it's incredibly helpful to listen to these comments, because we want to find what is the right balance between serving the public and protecting the public at the same time. So that's really all I had to say. Thank you for inviting me, and take care.
Thank you, Mr. Johnston. Next, we have Miriam Mizell, but I think that she might have disconnected. So next would be GRCCO. You may unmute and please identify yourself.
Hi, my name is Gary Conway. First of all, I'd like to thank the town manager and all those within the town of Barnstable for making these regulations available for our review. I'd also like to recognize my complete support of all issues raised by Doug Wood in his March 17th letter with attachment. Thank you for providing this forum. That concludes my remarks. Thank you.
Thank you, Mr. Conway. Next, we have Ellen Cummings. Ellen, you may unmute.
Yes, good afternoon. Ellen Cummings, Verizon State Government Affairs. Thank you for the ability to attend the public hearing today. At this time, I have no comment.
Thank you, Ms. Cummings. Next, we have Joanne. Joanne, you may unmute and please provide your last name as well. Thank you.
Hi, my name is Joanne O'Connor. I echo the others' thanks to the town for putting this together and for holding this hearing. I have no further comment today.
Thank you, Ms. O'Connor. And next up, we have Robert Wenger. Mr. Wenger, you may unmute. Thank you.
I'm sorry, I didn't have any comments. I was just here to join, but I want to echo the comments by others. That thanks to the town manager and his staff for pulling this together and really helping us here in Centerville. We just got shoved down our throats the new pole in a residential area, and it always goes back to that federal law, the almost 30 years old, the 1996 Federal Communication Act, that we have no say. But it's great to see this local kind of ground roots effort, and we certainly appreciate the town manager, Nick and company, for helping us get going. So thank you very much. Done.
Thank you, Mr. Wenger. Mr. Ells, I believe that is all we have for public comment.
Thank you, Director Poyant. I appreciate you facilitating that. So at this point, we certainly have recognized those comments in writing that have been submitted. We appreciate you reading summaries of those. We encourage any here and all those who are viewing or might view in the future to please submit comments in writing to us. Again, I'm going to hold that comment period open for 30 days to give people ample time. We'll review them as they come in. This will reside with our Director of Planning and Development and our town attorney for the review of these, and then ultimately advising me on the significance of the comments, the appropriateness of modification of the proposed regs. We'll communicate back out. I'll pause for a moment here. Attorney Nova. I assume that we will post a draft modified regulation if we modify the regulation so that the public can view that. Am I correct in saying that?
You are correct, although it is possible we will just post a final version. So it really depends on our review of the comments today.
Okay. But I will communicate that out to the public prior to us taking any action. So I don't want this to be a surprise to anybody. If though it is identified as a significant discussion, a significant or a substantial change to these proposed regulations, it will be my intent to post that and to hold another public hearing to allow for additional comment on substantial changes to these, okay? So on one hand, I want to be able to move forward and adopt these. They've been long in development. On the other hand, if it's substantial, we will continue this process. At this time, seeing no further comment, I will close the public hearing. Thank you all for attending. It's greatly appreciated.